hear from the man himself, Judge Eric Yost. Your Honor.
Well, thank you very much, Karl, for that very nice and warm introduction. I can tell you that I would be willing to swear under oath that President Ford never made a pass at me. I can state that without equivocation. I do want to say, first of all, thank you, Karl, for your public service. Karl Peterjohn is one of the individuals that I believe is a testament to the fact that people can get involved and will stay true to their principles. And he did that the entire time he held office, and I want to say I appreciate that. I want to also point out that Commissioner Ranzau, who I see back there now, and I'm sorry I haven't had a chance to say hi yet today, but Commissioner Ranzau is in exactly that same boat. He is a person is a person of great personal integrity and political consistency and honesty. And I told people that if you ever wanted to know what Ranzau wanted to know think about something, just ask him, because he will tell you exactly what he thinks, and that's a very rare thing in politics. I want to welcome all the legislators and candidates for office. I especially want to recognize two judges, Kevin Mark Smith, who replaced me on the bench and gave the invocation here today. Judge Smith, good to see you. I appreciate you and your public service. And Judge Linda Kirby, who I appeared in front of yesterday and provided testimony, and it was my first time testifying on one of the cases that had been sent to me by Judge Kirby, and it was a real interesting experience for me. I don't know if it was for her, but it was interesting for me to be able to play that role after I've been a judge for 19 years. And so, Judge Kirby, it's good to see you, and thank you for what you've done. When Karl asked me to come speak and said he would like for me to talk with you all about mediation, I thought he was kidding, because who on earth would want to hear something about the dry topic of mediation? He goes, oh, no, we think it's really, really interesting. Of course, I'm well aware of the hardship of the committee that designed to get speakers to come talk. And so I'm not kidding myself, but I will say that there are things that happen in mediation that are very interesting, and it's actually a pretty important part of our system, and I'm very happy to talk to you about it. For those of you who don't know what mediation is when two or more parties, and oftentimes we have 3 or 4 parties, meet with an impartial person, the mediator, in an effort to resolve their differences without having to go through the time and expense of a trial. Now, that sounds very sensible and logical, but there are a lot of people who don't do it. They still go through the old-fashioned way of dealing with their disputes. You'll be happy to know that while, yes, licensed attorneys can be mediators, and I am a licensed attorney, even though I'm a retired judge, other people can serve as mediators also. There is some training you can take here in Wichita that you get the training, you get the certification, and then you get approved by the folks in Topeka, and you can serve as a mediator just like any attorney or retired judge or anyone else. So if you've ever had a great desire to do shuttle diplomacy like Henry Kissinger, going back and forth between Israel and the Arabs, then this might be something that you would enjoy. Mediation, the ability to get something resolved without going to trial will save people enormous amounts of money. I know now more as a retired judge than possibly I knew before I became a judge what all that entails, but I can tell you that people spend tens of thousands, if not hundreds of thousands of dollars on lawyer fees and other costs, pretrial motions, discoveries where you find out what the other person's got, and the other person finds out what you've got and what you're going to say, and you take depositions, and then you go to trial, and it's a 3-day trial, and who knows by the time all that's over with how much you've spent. So mediating a case a year ahead of that is something that you can save money on. It also saves you time, because even after you've gone through all of that, and after you've spent all that money, you've had your trial, somebody might very well appeal the outcome of that trial, and that could take, with the Court of Appeals, not that long, but with the Kansas Supreme Court, I know people have had cases in front of the Supreme Court for literally years at a time. So it does give you an opportunity to save time. That reminds me, about 2 a.m. last night, I was awakened from my slumber by an Amber Alert, and I don't keep my phone right by my bed. I keep it in another room, so by the time I got to it and realized what it was, I was awake. And so if I fall asleep here, during my own remarks, feel free to just make a noise or drop a book or something. In addition to saving time and money, it saves embarrassment. It saves the heartache of going into court and having people who were friends or relatives or children or parents having to testify honestly and openly about things that, the lawyers and the judge might be done with you after one day, but you will have to live with that testimony for the rest of your lives. And I know people who still remember something that their neighbors said about them 20 years ago in a trial, or something their own child or their parents said. It's very heart-wrenching in some cases, depending on what kind of case it is, to have to do with that. And you can avoid that by having a mediation and resolving your case. So here's how it starts. I can tell you a mediation can be voluntary or it can be court ordered. And I want to talk to you about the voluntary. We have people who call our office and say, we're thinking about filing this lawsuit against someone, or we're thinking about filing for divorce, or whatever, and we would like to come in and, before any of that has happened, see if we can mediate our differences. To me, those are the most brilliant people on the planet, because they quite often will do that without even securing advice of counsel. Now, sometimes you need to have advice of counsel, but if it's largely what I call an equitable claim, who gets the car, or who gets to divvy up what's in the house, or let's look at this contract and let's see what it really says, instead of we don't want to spend $20,000 to save $25,000. We want to come in and maybe get it mediated. Those are the folks who do voluntary mediation. Sometimes the lawyers will come with them in a voluntary mediation. Sometimes the lawyers will look at a case and say, this is a wild case, and we don't even want to go in front of a judge with this. We want to get this thing resolved. And there are certain sets of facts that I have to tell you, you don't want to take certain facts into a courtroom in front of a jury, because sometimes it's very complicated. Sometimes it's just embarrassing. Sometimes it seems almost insane, some of the stuff that happens. In our little doodah here, there's a lot of wild stuff that goes on that I actually never was fully aware of until I became a judge. There's a whole world out there of people that are, half of the people out there driving are driving on suspended driver's licenses, and the other half, are right on the bubble. And so it's a lot of stuff going on, and they bring that into the courtroom, and there's a lot of human beings have a lot of conflict, and we have a mechanism, we have a court system for dealing with conflict that maybe other animals in the animal kingdom don't have. That they have about 2 other ways of dealing with it, and we don't. We are a reasoning species, and so we try to sit down and do it in a peaceful way And one way to avoid having to go into a long, expensive trial is to mediate. We also, I will tell you though, and this is more of a strategic thing. I see several attorneys in the room here today. Sometimes lawyers will pull the trigger a little too soon on the mediation, and they don't really fully know everything about their case. And so they're sitting in a mediation room and the other parties in the other room, and they'll say, you know, I don't know what this guy is talking about. I never signed any kind of a personal guarantee. And I'll take the piece of paper out that is a copy of his signature on a personal guarantee. Well, that's the first time his lawyer has seen that. Yikes! You know, that's a little embarrassing. It's a difficult moment. I usually leave and let them talk about it a little bit. But it's a lot better to have that happen in a mediation room than in a courtroom in front of a jury and a judge. Because I will tell you, I've seen that as a judge, when lawyers are truly surprised by something their client did or said that they had no inkling of. It is not a pretty moment in the career of a lawyer to have that happen, but it does happen. We do have quite a number, in fact, I would say a majority of the mediations that I perform are court-ordered. The judge knows a little bit about the case and says, oh my word, you know, this really needs to be mediated rather than being put in front of a jury. Because I don't know what a jury would do with this. Or I don't know if the jury would hate us after 4 days of all of this in and out. And so they do attend sometimes, the lawyers do attend sometimes. There's actually a statute, though, that says that there's one kind of mediation where lawyers are prohibited from attending. And I think a lot of lawyers don't know this exists, but in family law, where people are negotiating issues related to custody and visitation, lawyers do not attend, and that's a statutory provision. I will tell you that sounds terrible for lawyers, and it's not. It was actually passed, I think, at the request of lawyers who feel like they're not saving their client any money if both of them show up with the meter running, and you've got a mediator with the meter running, and and then you have an all-day mediation. So they send their client in to make their case to the mediator, and the mediator deals with whatever issues come up. I will tell you that as many different mediators as there are is how many different styles we have of mediation. Some mediators, I will tell you, they like to get everybody in the room at the same time and have a little Donnybrook and work it out if they can. I don't do that. Maybe that's more of a personality thing for me, but I have 2 separate rooms, and I have a third room that I have available to me if I have more than 2 parties, where I keep them in separate rooms for the most part. And on occasion, the parties will say, we get along fine. Let's just all get in the same room and save you the time of walking back and forth. Oh, now I have fallen for that a couple of times. And I usually regret it, because they then suddenly remember all the things this other person has done that has annoyed them, and I have to hear about it then. Whereas if the person's in the other room, I can tell you that what they say about each other, when I'm meeting with them privately, I do not go in the other room and tell them everything that is said about them, all right? My job is to get them to resolve their differences, not to escalate those differences, into some sort of nuclear warfare. And so, it's easy to do that when they're in separate rooms. If you're in the same room, that stuff still gets said, but I'm not there to help filter it and to keep it to myself. So I do seat them in separate rooms, and the first thing we do, and this is by Supreme Court rule, is we have them sign a consent to mediation, which has your basic stuff that you would expect, like them saying, we understand that Mr. Yost is not our lawyer. He's no one's lawyer. He's here to help us, and There's no lawyer-client relationship. It is confidential. It is completely confidential. I'm actually someone who thinks that I can't even stand here and tell you that Joe and Mary had a mediation, much less what happened at that mediation. I think I have to be careful about that. I can be ordered to do that by a judge, but even then, no judge has ever asked me to come in and talk about anything that was said or done at a mediation. By law, the only thing I can tell the judge is that if they were sent to me by the judge and then didn't show up, I can tell him they didn't participate. That's about all I can discuss. Thank goodness the mediator has no decision-making authority. So no one can call upon me to say, can't you just decide this for us? There are some types of cases that I get sent where I'm asked to make recommendations to the court. Those are not mediations, though. A true, pure mediation, the mediator has no decision-making authority. Only the parties can decide this case. Only the parties can decide to settle this case, which in most cases they should do. What I do, though, is I go back and forth. And some people call that being a water carrier. I do a little more than carry water. I do more than just, oh, you want to do, $50,000 and this guy wants to do $50, and so I just go back and forth until they resolve it. I don't do that. I kind of nudge them and I talk to them a little bit. I share with them some of my experiences as a judge as to what I think is possible. And of course, with Sedgwick County Jurors, I can tell you anything is possible if you go to trial. And I did close to 150 jury trials as a judge in my 19 years, and I used to gamble with my assistant as to how things were going to turn out, and I had a front row seat. I mean, I was paying attention to what was being said, and quite often I had it wrong. I mean, you never know what a jury is going to do. I go into that room and I say, it could get bad. You could go to trial and this could be awful. I see there are a few people here, maybe of an age, who remember the great old days of the KFDI mobile units when there would be weather coming in. How many remember the KFDI mobile units? Okay. Well, I will tell you, I used to love listening to KFDI. The mobile units would go out. We know there's a storm coming in, and so there'd be like a half a dozen of these little mobile units. They'd be out searching, for whatever it is that's coming from the sky, the frogs and the locusts and the hail and everything else, and they'd be driving around and they would be calling, and every 10 minutes we'd go to mobile unit number 4, or mobile unit number 2. And by the time the storm is kind of on top of us in Wichita, by then, the KFDI mobile unit is telling you, oh my God, I see my dead Uncle Henry. He's waving me towards the white light. That's I have to get off the air now to save my life. When in fact it was just kind of raining, for the most part. Well, when I meet with people in a mediation, I don't tell them that they're going to see their dead Uncle Henry when they get to trial, but I do tell them the truth, which is that there are going to be things that are said about them. There are going to be biases on the part of jurors. By the way, there's nothing wrong with jurors having biases. Every human being on the planet has them. What we ask jurors is, can you be fair? And of course they all say, oh, sure, I can be fair. Yeah, you bet. But they've got certain biases that are going to come into play in their decision making. And people need to be aware of that. When they get to trial, they have no idea what goes on back in that room. I was very fortunate. I had a young assistant who, when I left the bench, she moved to Johnson County and became a school teacher in Johnson County. But when she was up there, she got called for jury service. Now, she had sat through probably several dozen jury trials with me. But of course, she had never seen one from the perspective of being a juror. So she goes in for jury selection and makes the mistake of admitting that she had worked for a judge and had worked in Sedgwick County and was familiar with jury trials. She was thinking very cleverly that would get her out of jury service. It did not get her out of jury service. It got her made presiding juror in her jury trial. And so they have this 2-day hearing. It was a criminal matter. And they're back in deliberations, and she's telling me, I can tell she's frustrated because she can't really convey to me the true nature of how lunatic some of the folks are back in the jury room, okay? And the judges, of course, have already given written instructions and read the instructions and said, you may not consider the fact that the defendant did not testify, right? It's a big thing. It's in the Constitution. You know, I've read it. And so they're back in that jury room, and the jury, first thing the jury says, well, I didn't like the fact that he didn't testify. and my assistant said, are you kidding me? It says right here you can't consider that. Well, to be honest with you, if I was innocent, I'd be saying so. Oh, okay. And she would just go down the list of the instructions that the court had given to the jurors and the extent to which they either discounted the importance of those instructions. You do not, and that was a criminal matter. In civil matters, the instructions are actually a lot more complicated and there's a lot more to it. But even so, I think when you go to trial and you have a jury trial, you are rolling some big dice every time. And so if you have a chance to work it out ahead of time, you should do that. So my job, when you are in my little world of doing mediation, my job is to find some sort of a pathway whereby you and the other party can reach some kind of an agreement. And sometimes I have to be kind of creative about how to do that. Because I think in most cases, they do want to work it out. I tell them all right at the very front end, I said, look, if either one of you don't really want to reach an agreement, you won't. There are some knuckleheads who want to go have a big fight. Because they're so sure they're right, and they're so sure the jury is going to love them and hate the other person. Oh no, I don't want to work anything out. I can't wait to get into trial. Well, of course, those are the guys you always hear about 6 months later that it was a disastrous trial for them. You are always much better off trying to work out your differences, and I can give you horror story after horror story of lawyers who, and they're very nice about it. People will come in and they'll start out. I've had cases where one party wants $400,000 and the other party wants to give them $500, and that's after about 3 hours. And of course they said, I really don't want to give the $500, but I guess I will. Well, sometimes and by the way, I've had them that far apart where they reached an agreement by the end of the day. But there's others where they will get some offer that insults them, and they'll just storm out of there. Oh, I'm going to get $200,000 against you. And then I'll get a call 6 months later from the lawyer, having a little chuckle, saying, well, he got $5,000, or whatever it's going to be. You do not know what's going to happen. If I am able to get them to reach an agreement, I will prepare a little one-page agreement there on the spot and have them both sign it. Just the other day, I had a couple from another county come in and say, we don't have any money. All we've got is debt. We're trying to save a little bit. We would like to mediate our issues with you. And then they took that, and we reached an agreement, and we took that one-page agreement, and they then walked over to the Sedgwick County Courthouse and attached it to a petition for divorce and said, this is our deal. And that's perfectly acceptable. By the way, you can get divorced anywhere in Kansas. People don't really know that, but if you're from Sedgwick County, you can file for divorce in Ness County if you want to. We do that. I think it's done for the benefit of people live in smaller communities and everyone knows what everyone else is doing, and they kind of prefer to come into the big city where no one knows who they are and hash it out. So I get a fair amount of the smaller communities around Wichita that people drive in and would like to reach some sort of an agreement. And these folks did that. They reached an agreement and they attached it to the case hadn't even been filed yet. I think that was a very wise, although it was very sad because it was a very weepy thing. They would take turns crying, about their marriage having failed, but it was something that they had both concluded was inevitable. And then if there is an agreement, the statute related to mediations requires me to, if it was a court-appointed mediation, it does require me to write to the judge and say, Judge, they've reached an agreement and here it is, so that it is part of the record and it is part of the file. And then the lawyers usually will take that, if there are lawyers, and they will prepare a more legalistic sounding journal entry. But the elements of I can tell you that I prepare mediation agreements for people who speak plain English, and if the lawyers want to make it fancier, they can do that, and they certainly have that opportunity. So I'll tell you, it's been an interesting experience for me. I tell people, I'm glad we've got two former commissioners in here. I tell people that they say, how can you stand being in the room with or doing a mediation between two people who hate each other? I said, are you kidding? I was county councilor. I had 5 people who hated each other. I mean, this is nothing. So it's been interesting for me, and I've learned. I didn't know for sure that I would like it very much, but I have had an opportunity. I'm reminded that in my life, when I served in the legislature, especially when I was in leadership, I did a lot of this type of thing where you have people who we can't get adjourned until these two people work out their differences on some bill that we can't leave without passing. And a lot of times I would help mediate those disputes. And then, of course, as a judge, I did volunteer on a fair number of occasions as a judge to come in and help mediate. A lot of judges won't do that, but I did it. And you're always better off. The judges are better off if people get their case worked out without having to have a trial. So I've enjoyed that. But I would be very happy to stand for any questions or discuss anything else you'd like to talk about. Is that Mr. Todd?
As always, we'll start with members for questions, and please do make sure you have a question and not a statement.
It's a delight having you here with us today, Eric. Okay, question for you. Does mediation work in criminal cases, even cases as serious as murder?
Actually, they tried to do that in Johnson County. It hasn't been tried here in Wichita or in Sedgwick County, but I'll tell you, most criminal cases do get resolved. It's just that they don't have a third person helping mediate it. I was actually the head criminal judge for a year, and the lawyers would sometimes come to me and say, we would like to work out our case here, but we want to know if you will follow the plea agreement, and here's what it is. And I would say, yes, I'll follow that. So they do work it out, but there's no formal mediation process that I know of for criminal matters in Sedgwick County. There maybe ought to be, but it's more informal. They do settle most of their cases, especially during this last year during COVID when you could not get into trial. I think they're still not having hearings. I mean, my testimony yesterday with Judge Kirby was by Zoom. I'm not aware. I think maybe they have done a couple of jury trials, but they do very few still. But a year ago, they weren't doing any. And we have a speedy trial rule in this country where you're entitled. There are people sitting in that jail down there waiting for their trials, and it's very difficult to get a trial during COVID.
What determines the cost of your services?
Well, I mean, I think it's whatever the market will bear, and maybe a little bit less. If I can I can tell you I charge $225 an hour, which is less than what some people do. And that's just based on what I know people around town are doing. I'm not necessarily doing it for the money necessarily. I am a capitalist. I would like to make a little bit of money, but I certainly don't want to lose money. But I do want to have something, I want to do something interesting. I'm not necessarily trying to make a profit, but I am wanting to be helpful and productive even in my old age. So I'd rather have a little higher volume and charge a little less.
I have a question. What is harder, mediating a contentious family law matter or providing legal counsel to the county commission?
Karl, rebuttal.
Well, I think with the exceptions of the two angelic commissioners that we have here today, I found that I want to tell you the truth. I enjoyed my time as county counselor. I enjoyed the commissioners. A lot of really good people work at the county, and there were some problems at the end with a couple of commissioners, and I was disappointed. But for the most part, I was very favorably impressed with all of them, and all of them want to do what's right, what they think is right for the community. They sometimes had some clashes amongst themselves. I mean, I did have a couple of occasions where someone would told me as we were trying to figure out if they wanted something brought up or something had the votes to pass, and they would say, yes, I'll be happy to support that. And I said, well, good, that gives us 4 votes. Well, is that other guy voting for this? Well, yeah. Well, then I'm against it. Well, I had that happen a couple times. But for the most part, the commissioners want to do the right thing, and they're good folks. And so I would say that a contentious, if I had to do it over again, I did enjoy being county counselor, but the thing, there are other aspects of mediation that cause me to prefer that now, which is that I have a little more control over my own calendar, and I can take my time and kind of persuade people that what's in their best interest.
Thank you. Mr. Yost.
Hello, Judge. Hi.
I want to thank you for the insight that your mediation and your domestic conciliations, and you may want to explain to the audience what the difference is, but the level of insight you have brought. I've had more than a few domestic conciliations that you've been involved in, which do have an element of mediation involved in it, but they only get to us once you've made that recommendation.
Right.
But I have a question, and that is, are there people perhaps who are not well suited for being participants in mediation?
Are there some individuals? Well, there are people who are very difficult people who do come through my office, and you can usually tell it's by the volume of material they bring in. We count the notebooks, and if he's a 5-notebook guy, he's going to be a problem. Judge Kirby mentioned domestic conciliation. That's a fancy new word. What a domestic conciliation is where I try to help people reach an agreement. But if I'm unable to get them to reach an agreement, I then conduct an investigation, and I talk to their witnesses and read their documents, and I make recommendations to the court. And the court can do with my recommendations whatever the court wishes. So I have to prepare my written reports are usually somewhere between 10 and 15 pages long, and I think it gets the judge what the judge needs. I haven't had judges call me and say, we need more, because it takes a little time to read this stuff, and judges have a lot of reading to do. But I am, and I alluded to it earlier, just as a mediation is confidential and I can't talk about it, A domestic conciliation, there's nothing confidential about it. And I tell them that right at the front end, because whatever they tell me might end up in my report to the judge. And the judge has to know what that is. If you're not willing to reach an agreement, then that means the judge is going to end up having to make a decision. And the judge has the right to know what has happened. Thank you. Yes, sir.
So my question is different. You know, I read in the Wall Street Journal a couple of days ago saying that many students, they don't want to go to law school because they're not making that much money. They mentioned one student, he has a loan of $73,000, $73,000. He graduated from law school and he couldn't find a good job to pay off the loan. My question is, what can you tell the students to encourage them to go into law school?
Well, I would tell you, I've always believed that a legal education is very important. You know, not everybody who goes to law school ends up being a lawyer. There are a lot of people who use that education in business and in other things where they're not, they maybe don't want to be buffaloed by what some lawyer tells them, and so they've been to law school and they understand how things work. I will tell you that towards the end of my career as a judge, I started boring young lawyers by giving them unsolicited advice on what area they ought to go into, because I developed an opinion probably about 10 years ago that absolutely the best area to go into as a new young lawyer is probate. And of course, the minute you use the word probate, their eyes gloss over and they think, oh my God, you know, it's because everybody's 80 years old in probate. But here's the thing, in probate, you really do help people. You help them with their financial planning, with their deciding what to do with what they've got, and it's very important. And of course, a lot of those folks aren't going to be around if there's a dispute, and so you're there to represent their interests. If you've drawn their will or you've prepared their estate, their durable power of attorney, I really think it maybe sounds a little dull to some young people because they think it's all about LA law, you know. But probate is very underrated as a career for attorneys.
Let me get a better understanding of what percentage of your mediations would be fall into the civil court category versus the domestic category, and could you end up with any, since you mentioned probate, have you ever mediated a probate case?
Well, I'll do the last part first. I have received a number of assignments from probate, because probate also does guardianships and conservatorships, where there are people who don't necessarily want to have a conservator or a guardian, but their family feels they ought to have one. And a lot of times we will have to mediate that. The judge prefers that be mediated. I had one just last week, and it worked out pretty well. Grandparents were filing to become guardians of grandchildren because the parents maybe had some issues that their grandparents thought they needed a little help, and the parents didn't really want that help, and they were resisting that. And so we did get something worked out, and we got the grandparents to where they were kind of okay with what happened. So yes, I have done some probate. I don't get very many of the family feuds over money once, you know, one of the parents has passed away or something like that, because frankly what happens is they don't want to spend more money fighting over this little house or whatever than what it's worth. But it does happen on occasion. I will tell you that in the cases I've heard, I am not on the favored lawyer list for insurance companies where they have a lot of car wreck cases or a lot of medical malpractice cases. They have a handful of lawyers who do those, and the insurance companies can veto who the mediators are. I don't know why they haven't chosen to use my services, and I'm all right with it. So I would say that maybe a third of my work is civil, where the insurance companies aren't necessarily, I have done some insurance work, but a lot of the civil cases that I have are just people who have just a run-of-the-mill commercial dispute over workmanship in a home or a business or something like that. And I'd say maybe half of what I do is family law, where people are disagreeing about custody disputes, visitation disputes, money, financial disputes. There are people who have to, when they go through a divorce, unfortunately, they have to figure out what to do, who gets what, and who gets how much debt. And those are all things that are actually perfect for mediation.
Judge, to your left.
Oh,
Thank you,
hi, Mark.
Your Honor, for all your service. Thank you for being here. Thank you for so much service to the community. My question is, do you think that it's ever appropriate for a judge or the entire court to keep certain truths from a jury? Now, if you need me to give you a little bit of this, goes back 20 years, a case of my younger brother was accused by his ex-wife of having sex with their daughters. They moved between 2 different counties, and 2 counties brought charges against him. One county did a medical test on one of the daughters, and she's still a virgin. The other one was with her boyfriend all the time, so that wasn't the case there. But the one county did some investigation, the county where Bismarck, North Dakota is, and they said, this case is meaningless. We're going to drop charges. The other county, Oliver County, kept the charges, and they kept from the jury the truth that Burley had investigated and had dropped charges. I thought that was so unfair. And I have seen in Sedgwick County, courts will make agreements with the attorneys and so on, that certain truths are going to be kept from the jury. And I think that there should be a law against that. So I want you to, use your experience as a legislator. Should there ever be a time when part of the truth is kept from a jury?
Well, you say part of the truth, but in whose view? It's like the folks at Facebook deciding what's accurate and not accurate on the internet. I will tell you that as a judge, I probably did more than a lot of judges did to open things up for jurors. I allowed jurors to take notes. I allowed them to ask questions. That was a very radical thing, to let jurors ask questions of witnesses. But one of the most difficult things that judges have to do is decide what evidence is permitted and what isn't. And I'd have to know a little more about those cases, and I would have to know what the judge's rationale was. I was a person who kind of wanted jurors to have all the information. I think we do keep jurors in the dark too much, and they kind of resent that especially when the case is over and you go back and tell them a few things, and it offends them a little bit. But it just depends on the case, and it depends on what it is what piece of evidence you're talking about. But for the most part, I am sympathetic to your statement that I think we keep jurors in the dark too much.
Judge in the back.
Judge, seems ridiculous to even say this, but on the CNN or Fox, it stated that because of the internet and all the advice that's on there and forms and that 70% of the lawyers will not be needed 10 years from now. I'm not joking.
Is that a question or a celebration or?
70% is their job, yeah.
Well, and if that's true, then those folks will do something more productive. Hopefully.
Let us give a big round of applause to Judge Eric Yost.